Namaste and welcome to Daily News Simplified, the what, why, and how of newspaper reading. Now we would be analyzing the Delhi edition of the Hindu newspaper of 23rd of July 2019, and the news that would be covered today is given on the screen, and the timestamp for the same is given in the description and the comment section given below. And so now with this, let us start with the first section. Now, as part of our continuous discussion with regards to question asked in the prelims examination of 2019, the question that we're going to discuss today is that the chairman of public sector banks are selected by and there are four options: the Bank's Board of Bureau, the Reserve Bank of India, the Union Ministry of Finance, and the fourth option being the management of concerned bank. Now, if you take a look at the Daily News Simplified video of 20th of March 2018, in which the Bank's Board Bureau was explained, one of the functions of the Bank Board's Bureau is that it recommends for appointment of full-time directors and non-executive chairmen of public sector banks. Similarly, if you take a look at the Daily News Simplified video of 19th of December 2018, in which the Bank's Board Bureau was explained, one of the role of the Bank's Board Bureau is that it recommends the name of the heads of public sector banks. And lastly, again, if you take a look at the Daily News Simplified video of 19th of December 2018, as you already understand, we asked various questions for practice in Daily News Simplified video. And if you take a look at this question, consider the following statements related to Bank's Board Bureau, and specifically the second statement that it is empowered to appoint the head of public sector banks in India. You would understand that this statement is actually wrong, whereby the Bank's Board Bureau recommends the name to the Government of India on who to appoint as chairman of public sector banks. However, it is the Government of India which finally appoints the chairman of public sector banks based on the selection and the recommendations given by the Bank's Board Bureau. Therefore, if you take a look at the question which was asked in the prelims of 2019, the chairman of the public sector banks are selected, whereby what you would have understood from Daily News Simplified videos is that it is the Bank's Board's Bureau which initially selects and then recommends name to the Government of India for appointment as chairman to the public sector banks. And therefore the correct answer to this question would have been A, Bank's Board Bureau. So hopefully with this you get an understanding on how Daily News Simplified videos can help you in understanding with clarity any topic which has appeared within the Hindu newspaper, and hopefully with that understanding you would be able to solve the questions which are asked in your prelims examination. Therefore with this, let us move on to the first article for today. Now we have taken this opinion-based editorial from page 11. Now this editorial mainly provides a critique to the Right to Information Amendment Bill which was recently passed by the Lok Sabha. Now you should see this editorial and the upcoming explanation first from the perspective of GS Paper 2 within the section Governance and Polity, and you should mainly see the critique which has been highlighted within this editorial from the perspective of GS Paper 4 within the section Property in Governance, and specifically from the section Information Sharing and Transparency in Government and Right to Information. Now there are two main changes that have been introduced through the Right to Information Amendment Bill. The first main change is with regards to the term of the Chief Information Commissioner and of the Information Commissioner, whereby under the RTI Act of 2005, the Chief Information Commissioner and the Information Commissioners at the central and state levels needed to serve for 5 years. However, what has happened now is that under the 2019 Amendment Bill, it would be the central government which would decide the term of the Chief Information Commissioner and of the Information Commissioner, whereby unlike the 2005 Act, the term of the CIC and the IC would not be a fixed term of 5 years and would rather be decided by the central government. The second main change which has been brought about through the Right to Information Amendment Bill of 2019 is that the salaries, allowance and other terms and conditions of the services of the Chief Information Commissioner and of the Information Commissioners, including at the centre and state, will be decided by the central government. Now what used to happen earlier is that under the RTI Act of 2005, the salary of the Chief Information Commissioner at the central level would used to be equal to the salary of the Chief Election Commissioner. And similarly, the salary of the Information Commissioner at the central level used to be equal to the salary of the Election Commissioner. Similarly, at the state level, the salary of the Chief Information Commissioner was equivalent to that of an Election Commissioner. And similarly, the salary of the Information Commissioner at the state level was equal to that of the Chief Secretary of that state. However, what has happened under the 2019 Amendment Bill to the Right to Information Act is that the salaries, allowance and conditions of the Chief Information Commissioner and Information Commissioners at both central and state level would be decided by the central government. Now it is regard to both of these changes that the Right to Information Amendment Bill has been criticized by the author in today's editorial. Now before understanding the critique given by the author, let us first understand as to what is the reason of the government to bring these two main changes to the Right to Information Act. Now the main reason given by the Government of India for amending the Right to Information Act is that it was a gross mistake of the previous government to create the service conditions of the Information Commission at an equal level to that of the Election Commission. Whereby the main argument given by the Government of India is that the Election Commission is a constitutional body, while the Information Commission is a statutory body, and therefore it was a gross mistake of the previous government to have the service conditions of both the Election Commission and the Information Commission at the same level. Apart from this, according to the Government of India, the functions and the powers of the Election Commission and that of the Information Commission are quite different, since one is a constitutional body and the other is a statutory body, and therefore it was a mistake of the previous government to have the service conditions of the Election Commission and the Information Commission at the same level. Now it is within this context that the author within this editorial has critiqued the recent changes that have been brought to the Right to Information Amendment Bill, and also the reasons given out by the Government of India for bringing about such changes. Now there are three main critiques given out by the author with regards to the RTI Amendment Bill of 2019. Now the first critique given by the author is that the information provided by the Information Commission is essential for effective governance and transparency within India. And therefore the working of the Information Commission should not be considered at a lower level when compared to other bodies such as the Election Commission. And therefore the reasons given out by the Government of India to changes to the term and salaries of the Chief Information Commissioner and Information Commissioner does not take into account the contribution and the role of the Information Commission in ensuring effective governance within India. The second aspect which has been highlighted by the author is that the Supreme Court has already said that the Chief Information Commissioner is the guardian of the Right to Information Act of 2005. And within that context, the Supreme Court has already said that the Chief Information Commissioner and Information Commissioner can be appointed on the same terms and conditions as applicable to the Chief Election Commissioner or the Election Commissioners. And within that context, the Supreme Court has already upheld the validity of equivalence or equality between the Election Commission and the Information Commission with regards to service conditions. The third and the final critique given out by the author is that the changes made in the Right to Information Amendment Bill will dilute the autonomy of the Information Commission and thereby allow the government to interfere within the working of the Information Commission, whereby it is the government which would decide the term of the Chief Information Commissioner and Information Commissioner and also their salaries. And therefore the individuals working in the Information Commission would not have security in terms of their service conditions, and thereby there would be a stronger chance of pressure by the Government of India upon the Chief Information Commissioner and Information Commissioners to give out information that is much more supportive or in favor of the government in power. Now these are the three main critiques given out by the author. Hopefully you've understood the main crux of this editorial from the perspective of GS Paper 2 and GS Paper 4. Now what you need to understand that this is currently a bill and has only been passed by the Lok Sabha and is yet to become an act. And therefore this Right to Information Amendment Bill should be considered and used in transition, whereby after it becomes an act, let us wait and see as to what would be the view of the Supreme Court also. So now with this, let us move on to the next article. Now I have taken this opinion-based editorial from the editorial page on page 10. Now what this editorial provides is a critique of a specific chapter of the Economic Survey, whereby this editorial provides a critique of Chapter 10 of the Economic Survey, which is titled Effective Use of Technology for Welfare Schemes, the Case of the MGNREGS Program, whereby the main critique given out by the authors within this editorial is that the information given out in Chapter 10 of the Economic Survey is quite misleading. Now as you already might be aware of, we're providing a detailed and comprehensive videos on each chapter of the Economic Survey, whereby the detailed analysis of Chapter 1 and Chapter 2 has already been provided. Therefore, with regards to today's editorial, let us wait for the special video on Chapter 10 of the Economic Survey, in which the information of Chapter 10 and its critique would be covered. And so now with this, let us move on to the next article. Now we have taken this article from page 9. Now what this article talks about is the Gharial crocodile. Now before understanding about the Gharial crocodile, let us first understand on how questions have been asked in previous prelims examination with regards to animal. Now, previously, several questions have been asked in your prelims examination with regards to a particular animal, while questions on animals such as gharials, great Indian hornbill, khadai camel, and others have been asked in your prelims examination. And questions on animals within the prelims examination have generally been asked with regards to their status under the Wildlife Protection Act of 1972, their habitat, or one of its unique features. And apart from this, for your prelims examination, also try to understand as to the reference of the animal within the IUCN list or any other major international protection scheme. And therefore, by understanding the habitat of an animal, its status under the Wildlife Protection Act of 1972, and lastly, by understanding the unique feature of that animal, you would be able to have a comprehensive coverage with regards to your upcoming prelims examination. And so now with this, let us move on to understanding the article for today. Now the reason the Gharial population is currently in the news is because the state of Odisha intends to revive the Gharial population within their state, whereby the state of Odisha intends to increase the population of gharials within their natural habitat, which is located in the Satkosia range of the Mahanadi River. Whereby if you take a look at this map, the Mahanadi River forms the southernmost limit of the gharial population within India. Now, an important fact that you should also know is that Odisha is the only state within India which has all the three species, the gharial population, the mugger, and the saltwater crocodile. Now, apart from this, as we have already understood in the previous section, there's some important facts about the Gharial crocodile that you need to remember from the perspective of your prelims examination. Now, the first fact that you need to know is that it is listed as critically endangered in the IUCN list. Apart from this, the second fact that you need to know is the habitat of the Gharial crocodile. Now, the Gharial crocodile is extinct within the country of Bhutan, Myanmar, and Pakistan. And according to IUCN, the current extent of the Gharial crocodile is limited to Bangladesh, India, and Nepal. However, what you should understand is that the gharial population within the country of Bangladesh is quite few, whereby the population might be even less than 10, and it is most likely that they would become extinct within the country of Bangladesh. However, IUCN till date has not listed gharial crocodile as being extinct within the country of Bangladesh. Therefore, what is currently being seen is that the gharial population is limited to 14 localities within the country of India and Nepal. Whereby within India, the surviving population of the gharial crocodile is limited to the Girva River within Uttar Pradesh, the Son River within Madhya Pradesh, the Ram Ganga within Uttarakhand, the Gandak River within the state of Bihar, the Chambal River which flows through Uttar Pradesh, Madhya Pradesh and Rajasthan, and the Mahanadi River located in the state of Odisha. Now, within that context, what you should also know is that the National Chambal Sanctuary is the location which contains the largest population of the gharial crocodile. Now, apart from this, what you should also know is that the gharial crocodile is mainly threatened from land fragmentation through the use of agriculture and urbanization. However, the most important threat against the gharial population is the formation of dams across rivers within India, whereby the formation of dams across river threaten the habitat of the gharial population. And the last aspect that you need to understand about the gharial crocodile is that they are protected under Schedule 1 of the Wildlife Protection Act of 1972. Now, these are the important facts that you needed to understand about the Gharial crocodile. And so now with this, let us move on to the next article. Now, we have taken the first article from page 1 and this article continues further to page 12. Now, what has happened is that the US President Donald Trump has said that during the recent G20 summit that was held in Japan, there was a meeting between the US President and the Indian Prime Minister, in which Donald Trump has said that the Indian Prime Minister requested him to become a mediator on the Kashmir issue between India and Pakistan. Now, within that context, what is required to be understood is the response given out by the Ministry of External Affairs, whereby the Ministry of External Affairs has said that no such request of mediation has been made by the Indian Prime Minister to the US President, whereby the Ministry of External Affairs has clarified that India's consistent position has that all outstanding issues that India has with Pakistan will only be discussed bilaterally, whereby what this means is that the Sir Creek issue, the Kashmir issue, or any other issue that India has with Pakistan will only be discussed on a bilateral level, and there is no requirement of any third-party intervention either of the United States, China, or the United Nations with regards to disputes between India and Pakistan. Apart from this, the Ministry of External Affairs has also said that any engagement between India and Pakistan on a bilateral level to solve any dispute will only happen after Pakistan ends cross-border terrorism. Apart from this, the Ministry of External Affairs has also clarified that any resolution of disputes between India and Pakistan on a bilateral level will be undertaken given the provisions of the Shimla Agreement and the Lahore Declaration, whereby the Shimla Agreement was signed between India and Pakistan in 1972 after the 1971 war. And similarly, the Lahore Declaration was signed between India and Pakistan in 1999. Now, these are the main facts that you needed to understand from this article from the perspective of GS Paper 2 within the section International Relations and within the subsection India and its neighborhood relations, in particular India's relationship with Pakistan. And so now with this, let us move on to the next article. Now we have taken this article from page 12. Now the reason why this article is in the news is not important with regards to your civil services examination. However, what is required to be understood from this article are three static concepts, first being adjournment, the second being adjournment sine die, and the last concept being prorogation. Now we have understood about these three concepts in a much earlier DNS video, and therefore what we're going to do in today's section is again revise them. And it is within that regard that we're going to understand these three static concepts from the perspective of your prelims examination. Now an adjournment suspends the work of a sitting house of a parliament, but the suspension is for a specified time, which can be of hours, days, or weeks. Now the power of adjournment lies with the presiding officer of the house. Now an adjournment only terminates a sitting of the house and not the session of the house. Now a session of the parliament is the period spanning between the first sitting of a house and its prorogation. And during this session, the house meets every day to transact business. So therefore, a session of parliament consists of many meetings, and each of these meetings in a day consists of two sittings. And therefore, adjournment terminates the sitting of the house and not the session of the house. Now hopefully up till here you have understood that adjournment suspends work of the sitting house of the parliament for a specified time, and this power of adjournment lies with the presiding officer of that house, wherein adjournment only terminates the sitting of the house and not the session of the house. Now adjournment sine die means terminating a sitting of the house for an indefinite period. Now it means that the house is adjourned without naming a day for reassembly, and this is called adjournment sine die. Now the power for adjournment sine die lies with the presiding officer of that house. Can call for the sitting of the house before any date or time for which it has been adjourned, or at any time after the house has been adjourned sine die. Now hopefully up till here you have understood that adjournment sine die suspends the work of the sitting house of parliament, but the suspension or termination of work is for an indefinite period, meaning the house is adjourned without naming a day for its reassembly. And the power for adjournment sine die lies with the presiding officer of that house. And once the sitting of the house has been adjourned sine die, the presiding officer can call for a sitting of the house at any time after the house has been adjourned sine die. Now let us understand about prorogation. Now prorogation terminates both the sitting and session of the House of the Parliament. Now the power of prorogation is done after an order has been made by the President of India. And prorogation can be done while House is in session or after an adjournment sine die has been passed. Now hopefully up till here you have understood that prorogation terminates both the sitting and the session of that House of the Parliament. And prorogation is made by an order by the President of India, and this order can be given while the House is in session or after an adjournment sine die has been passed. Now hopefully up till here you've understood as to what is adjournment sine die, and what is prorogation. And moreover, you can easily answer if a question on their differences is also asked. Now let us understand with regards to the scenario of the bills. Now in adjournment and in adjournment sine die, it does not affect the bills or any other business pending before the House. While in prorogation, it does not affect the bills or any other business pending before the House. However, all pending notices, except those for introducing bills, lapse and fresh notices have to be given. Now hopefully up till here with regards to scenario of bills, that during adjournment or adjournment sine die, it does not affect any bills or the business of the House, and same can be resumed when the House meets again. While in prorogation, it also does not affect the bills, or any other business pending before the House. However, pending notices, except those on the introduction of bills, lapse, on prorogation, and fresh notices have to be given for the next session. Now, apart from this, there's one more thing that you should understand. It's about dissolution. But for now, we will not be focusing on dissolution. And so with this, we move on to the next article. Now we have taken this lead editorial from the editorial page on page 10. Now as you already might be aware of, there are two main processes which is undergoing within the state of Assam. First being the NRC list and second being the establishment of the Foreigners Tribunal. Now both of these processes are undergoing within the state of Assam so as to separate the illegal migrants which have entered in the state of Assam from the actual citizens of India who are living within the state of Assam. Now, as you already understand, the Foreigners Tribunal has been established under an executive order of the central government, while the NRC or the National Register of Citizens is a process which is being overseen and driven by the Supreme Court of India. However, even though the Foreigners Tribunal has been established by executive order of the central government, the Supreme Court in the Abdul Qaddus case has said that Foreigners Tribunal are quasi-judicial bodies. Now, within that context, the author within this editorial has critiqued on how this position of the Foreigners Tribunal as a quasi-judicial body has created confusion and has led to various problems in forming the NRC list. Now, the first critique which has been given out by the author is that the Foreigners Tribunal do not resemble even remotely as to what should be a court within India. The second critique of the author is that the Foreigners Tribunal was established by an executive order of the central government and not by the Parliament of India as is seen with other courts and tribunals within India. The third critique of the author is that the qualifications to serve on the Foreigners Tribunal has been progressively loosened, whereby currently even bureaucrats can now serve on the Foreigners Tribunal. Apart from this, one of the critiques given out by the author is that since the Foreigners Tribunal have been formed by an executive order, then their decisions cannot be seen as being a judicial verdict or a judicial judgment. Apart from this, one of the main critique of the Foreigners Tribunal is that they have given several decisions in ex parte proceedings, meaning that whereby the individuals who are being tried within that case are not being heard. Whereby the author within this editorial has highlighted that in normal judicial proceedings, an individual who is being tried within a case needs to be heard by the judge who is overlooking that case. And the Foreigners Tribunal is giving out a verdict whether a person is a citizen of India or not without even hearing from that individual. Now, apart from this, what you should also understand is that the author within this editorial is heavily criticized the Supreme Court, especially the verdicts given out by the Supreme Court in the Abdul Qaddus case and also in the Sonawal case. However, as UPSC aspirant, it is best not to criticize the Supreme Court in a similar manner as has been provided by the author within this editorial. So now hopefully you've understood the four main critiques of the author with regards to the quasi-judicial status of the Foreigners Tribunal. Now apart from this, what you should also know is that in the Daily News Simplified video of 10th of June 2019, the problems with the Foreigners Tribunals in Assam and the problems with the NRC within Assam has been comprehensively covered. And what I'll do is provide you with a link to this video in the description section given below, and from which you can further understand what are the problems with the Foreigners Tribunal and with the NRC list within the state of Assam. But hopefully in today's editorial you have understood as to what are the problems with regards to the quasi-judicial status of the Foreigners Tribunal. And so now with this, let us move on to the next section. Now there are two questions for practice, and what you need to do is pause this video, solve both of these questions and wait for 5 seconds for the correct answer. Now with regards to question number 1, the first thing that you need to know is that statement number 1 was asked in the prelims examination of 2016, while statement number 2 and 3 were asked in the prelims examination of 2004. Now with regards to statement number 1, a bill pending within the Lok Sabha does not lapse on its prorogation. While with regards to statement number 2, the Speaker of the Lok Sabha has the power to adjourn the House sine die. But with regards to prorogation, it is only the President of India who can summon the Lok Sabha. And therefore the correct answer to question number 1 would be B, 2 and 3. Now with regards to question number 2, the correct answer is B, 1 and 3. Now as we have already understood, the Election Commission of India is a constitutional body, while the Central Information Commission is a statutory body which has been formed under the RTI Act of 2005. Now statement number 2 is incorrect, whereby the Election Commission of India is not exempted from the purview of the Right to Information Act of 2005. While statement number 3 is correct that the decision of the Central Information Commission is binding, which has been provided under Section 70 of the Right to Information Act of 2005. Therefore, the correct answer to question number 2 would be B, 1 and 3. Now there are two more questions for your practice, and as you already understand, pause this video, solve both of these questions and wait for 5 seconds for the correct answer. Now the correct answer to question number 3 is B, 1 and 2. Now the Gharial crocodile is listed as critically endangered in the IUCN list. With regards to statement number 2, the Gharial crocodile is protected under the Schedule 1 of the Wildlife Protection Act. And similarly, the tiger is also protected under Schedule 1 of the Wildlife Protection Act. And therefore the Gharial crocodile is provided the same protection as the tiger under the Wildlife Protection Act of 1972. Now statement number 3 is incorrect. Now, even though the Gharial crocodile has been extinct within the country of Bhutan, Myanmar, Pakistan, and is most likely to go extinct in the country of Bangladesh, what has been seen is that the population of the Gharial crocodile has actually increased within India. And therefore, the IUCN has said that the Gharial crocodile is not on the verge of extinction. Now, with regards to statement number 1 of question number 4, the Shimla Agreement of 1972 was signed by Indira Gandhi and President Zulfikar Ali Bhutto of Pakistan, whereby the Shimla Agreement was a comprehensive blueprint to establish good neighbor relations between India and Pakistan, whereby what had happened was that both the countries agreed to several confidence building measures so as to improve the relations between both of them. Therefore, within that regard, the Shimla Agreement of 1972 was not solely a peace treaty, and within that regard, statement number 1 is incorrect. Now, with regards to statement number 2, the Shimla Agreement does not support third-party intervention for resolution of territorial disputes, whereby under the Shimla Agreement it was decided upon between India and Pakistan that any territorial dispute, especially on Kashmir, would be solved bilaterally between both the countries. However, statement number 3 is correct that the Shimla Agreement officially led to the establishment of the line of control in Jammu and Kashmir. Therefore, the correct answer to question number 4 is C, 3 only. And now with this, we come to an end in the analysis of today's newspaper. Now we move on to the question for today.